Madam Moderator, I hope the PowerPoint doesn't work. I'm prepared anyway. Okay, thanks. Just to say, distinguished guests, colleagues and friends, it's really an honor to be here, to have so many of you here with me. I thought what I should do is talk a little bit about the challenges of drafting legal aid legislation in countries, developing countries with very few lawyers, and also to think out of the box a little bit. We heard this morning, we heard some of our speakers, I think our first speaker, Judge Dunstan Malambo, said we should be honest and objective about what is going on with legal aid, and I think he really set the tone. That's what I'm going to try and do. We had somebody else saying that we should return to the realities of people's lives this morning, and then we had also that the Chief Justice of South Africa saying we must reconnect with reality. So I thought what I would do would have a look, if you look at the introduction, I've got a robot somewhere clicking the PowerPoint for me. I don't know if he's got my next slide yet, but anyway, what I'm going to talk about is the challenges that you face when you're drafting legal aid legislation. Often what we do is we will have stakeholders meetings. You develop a policy, you get all the stakeholders involved, you develop the bill eventually, everybody agrees, and then it goes off to a drafting department, and the drafting department starts making changes which got nothing to do with the policy, and then it goes off to the Minister of Justice's office, and then he sends it out to judges or somebody who hadn't attended the seminar, and they strike out everything else. And I want to give you some examples of things that we try to put into acts which are completely consistent with this United Nations guidelines and principles, but were rejected. And I want to just look at some of them. If you go to the next slide, robot, wherever you are. And just to say, these principles, and in my experience apply, it doesn't matter whether you come from a civil law jurisdiction or a common law jurisdiction, these principles apply to all of them. The things I want to look at are firstly what I call the big city syndrome, which seems to affect the judiciary and the bar associations. Then I'm going to talk about lack of confidence in traditional legal systems. We heard that CJ mentioned that briefly. Then I'm going to talk about skepticism of using paralegals and skepticism of using law students. And then the failure to look at the value of assistance without representation. The House of Lords had a Mackenzie friend rule, which we've tried to introduce, and people seem scared of it, but we will talk about that. And then I want to talk a little bit about over-bureaucratization, and then lack of resources. I've got, 8 minutes left, so let me try and get through this one. Okay, slide, just hit the next slide and go through to, I'm not going to talk about the principles because you've seen them. Let's move to challenge 1, the big city syndrome. When I say countries with small lawyers, I mean a country of 6 million with 100 practicing lawyers, or a country of 5 million with 100 practicing lawyers, or other countries where you've got literally hundreds of people, thousands of people out in the rural areas. One country I was within, you had 96 out of 100 lawyers were in the capital city, and 4 lawyers were out in 2 towns. Now, those are the sort of areas I'm talking about. And what happens, though, the lawyers, when they look at these things, seem to think they're sitting in, I don't know, Paris, London, New York, you name it, and they forget about those people in the rural areas. And I'm going to tell you at the end what one of the presidents of a country told me about that. So let's just go to challenge 1, the example. Next one, slide, projector guy. Okay, look at these 2 clauses very quickly. These were clauses we wanted to put in. In towns, especially in rural areas where there are no lawyers and where lawyers will not go, the court has the discretion to allow paralegals, law students and lay advisors to assist, but not represent litigants and accused persons. That was struck out. That's the Mackenzie friend rule. We had a caution there because we said where an unrepresented accused person, even if they're assisted, that case would go on automatic review, which is a principle we have here. A judge in chambers would simply certify that case was decided in accordance with justice. That was one mechanism we thought of where it was necessary to use self-help. Can you just go to the next slide, please, looking at traditional, next one. Okay, all of this you're going to get on your memory stick. This was one where we wanted to deal with traditional situations, because in many of these countries, the majority of people live out in the rural areas. So we had 2 clauses here. We had one which said, Where an accused person is charged with a minor offence, community-based paralegals may assist the prosecutor to divert the case to a traditional dispute resolution mechanism, provided it is consistent with fundamental human rights. We put that in. We said when it's not in the interest of justice for the person to come before that court, the paralegal should advise the chief or traditional leader that case must go to the courts. Now that seemed perfectly logical. That was struck out. Judges in that particular country didn't want to know anything about traditional legal systems. It's right in line, again, with what the principles say. Okay, let's go to the next one. Next one, challenge 3. Yeah, right. This was another one which we wanted also. Rural areas and small towns where there are no lawyers. So we suggested a clause here. In small towns, paralegals are stationed at every court, because you have courts there, but you don't have lawyers, to assist court officials in ensuring that access to justice is provided by providing legal advice and assistance or referring persons to legal aid providers. In rural areas, they're stationed at every traditional leader's office. Again, we put all this in. Again, it was all struck out again by the legislators in their wisdom. Right, we go to challenge 4, please. I'm just giving you these examples because you will see when you look at, thank you, half time. If you look at them, you will see that these are consistent, and I'll put it at the bottom, with those principles that we're talking about today. We've been invited to think out of the box, and I want us to think a little bit about these things. Okay, this was one now about student practice rules and using law students, the same way that one would use paralegals. The irony is that in some of the developed countries, they have student practice rules, even though they've got hundreds. They've got the country with the biggest amount of lawyers has got student practice rules. Philippines are here, we can give them a pat on the back. They do it, and some of the South American countries. But a lot of other places, again, they're scared of this, even when the students are being supervised by qualified lawyers, even in areas where there are no lawyers. So again, there was a recommendation. Next one, please. Challenge 5. Okay. This was one now. All of these are things that everybody bought into, all the stakeholders. But when it ended up in the Ministry of Justice, the lobbyists got involved, and that was the end of it. This is again just spelling out how that Mackenzie friend would work. And we put into it, we said, before the trial, a paralegal, law student, or lay advisor, which is what the House of Lords said, may advise and assist litigants regarding civil claims and accused persons on preliminary matters, including bail applications, pleading to charges, etc. During the trial, a paralegal, law student, or lay advisor may take notes and quietly advise and assist the accused or litigant, suggest questions to the accused or litigant, assist the accused person or litigant. Again, in cases where you had someone assisting you, these would go on automatic review to a High Court judge in chambers just to say this is in accordance with justice. Okay. Next one, challenge 6. Chair, we're nearly there. All right, this is one about bureaucracy. A lot of countries I worked in where you had had previous regimes where the Ministry of Justice not only, but there were certain requirements. You had to get all sorts of documents from all sorts of different people to make an application for legal aid. And of course, you had to get all these documents certified by different people. It was open to bribery and all sorts of things. What we've found out, and we do it in South Africa fairly simply, is that they've got a salary slip, they bring one. If they haven't got one, they make a sworn statement or whatever. If you make a false statement, you can be prosecuted for it, and then you have emergency legal aid in situations. Quite a lot of those have been adopted, and it's something that we should make sure that it is accessible by making it easy. Okay, challenge 7, please. All right, this is just funding allocation. Now, this is a thorny issue. I think just about every speaker mentioned it this morning to us. How do you work out what is a reasonable funding for the legal aid scheme? You heard the Chief Justice saying how you look at the money spent on all the other sections of government, but when it comes to the courts, very little. Well, legal aid, again, one way of looking at it is to look at, thank you, comparative countries and see what the per capita expenditure is. In South Africa, the per capita expenditure is roughly about $2 US each person. Out of that, though, you'll hear from them, is it 64 justice centers, 64 satellite offices doing They're doing over 60% of 600,000 criminal cases a year. They're doing 80% of 60-odd thousand regional court cases a year. They're doing 90% of high court cases on $2. Okay, not America that spends $15 per capita or anything else, but you can do a lot if you do it efficiently. Okay, well that's a lot. We can go to the end. Right, so conclusion then, you can use these principles and guidelines to come up with your policy. And that is what they set out. But what I was showing you was some of the implications. If you are going to do these things, you've got to focus in and see, well, how are we going to work to do this stuff? Developing countries with small numbers of lawyers, if you think creatively, there are lots of resources out there. All you've got to do is use them. And you've got to be careful, we've got to be objective. We can't just give in to vested interests coming in and trying to block it without thinking of what's going on with the majority of people. I put in there again, just repeated the first paragraph of the introduction to the principles. Legal aid is an essential element of fair, humane, and efficient criminal justice system based on the rule of law. I want to end, this is important because when I was doing this in Sierra Leone, the president said to me, he said the reason we had a civil war was that people in rural areas, the only time they ever saw the law was the police and the prosecutors. There were no lawyers out there. So the rebels came along and said, guys, join us, we will give you justice. And so they were able to undermine the whole system in Sierra Leone. So it's very, very important that we make sure in a democratic country we have a proper functioning legal aid scheme. Thank you. Time is due.